Welcome back to The Explainer. Today, we are doing something really cool. We're taking Section 2.2 of the Code of Civil Procedure 1908 and putting it straight under the microscope. We're going to bypass all the basic jargon and dive right into the invisible gears that actually turn the wheels of civil litigation, all to dissect the absolute cornerstone of a case, the decree. Okay, let's dive right in. Here's our roadmap. We're going to decode the decree, look at its 5 essential elements, figure out the inclusions and exclusions, break down the types, and then lock it all in with some real-world case laws. Section 1, Decoding the Decree. So picture this. You're at the climax of a long, exhausting civil trial. The lawyers have finally rested their cases, and the tension in the room is literally palpable. At the end of all that drama, when you finally win or lose, what is the actual, tangible, legal vehicle that declares it? Like in civil procedure, what is the piece of paper that truly hands you your victory or seals your defeat? Well, the answer is the decree. It is the absolute ultimate manifestation of the court's decision. You see, while a judgment gives you all the detailed reasoning, what the judge was actually thinking, the decree, that's the operational part. It's the bottom line. It's the binding resolution that tells everyone exactly who gets what. Now, let's look at the bedrock foundation here. I actually want to slow down for a second and read the exact statutory definition straight from Section 2.2 of the Code of Civil Procedure 1908. It defines a decree as the formal expression of an adjudication, which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit. Phew, that is a mouthful, right? But trust me, every single word there was chosen with mathematical precision by the lawmakers. Section 2. The 5 essential elements. I actually really like to think of a decree as a living, breathing legal organism. And for it to survive, it needs 5 vital organs: an adjudication, a suit, the determination of rights, a conclusive determination, and a formal expression. So the absolutely crucial point here is this. If a court's decision lacks even a single one of these elements, there is no way it's a decree. It's just an order. And let me tell you, the difference between an order and a decree is huge. Let's break these down, starting with the first 2. Adjudication basically means there has to be a formal decision by a judge. The judge has to genuinely apply their mind to the dispute, and this adjudication has to happen inside a suit. In the civil law world, a suit is a proceeding that kicks off when you file a specific document called a plaint. If you start things with an application or a petition, well, unless the law specifically says otherwise, it's generally not a suit, which means it cannot result in a decree. All right, moving to elements 3 and 4, the rights of the parties and a conclusive determination. The decision has to actually deal with the substantive rights of the plaintiff and the defendant regarding whatever they are fighting about. And here's the kicker. Provisional or, temporary decisions, they completely do not count here. The ruling has to decisively and finally settle those rights as far as that specific court is concerned. There is no, we'll see what happens next when it comes to the matters finalized in a decree. And finally, element number 5, formal expression. Look, a casual comment from a judge sitting on the bench, not a decree. Actually, even the written judgment itself isn't the decree. The court's reasoning literally has to be translated and drawn up into a totally separate, formally formatted, legally binding document, exactly as provided by law. That formal expression is the whole reason you can actually enforce it. Section 3. Inclusions and exclusions. Okay, so anyone who's spent even 5 minutes studying law knows things are rarely perfectly simple, right? We often have to deal with legal fictions, and this brilliantly illustrates that. On one side, we have what we call deemed decrees. By sheer legal fiction, the code explicitly treats the rejection of a plaint and certain restitution questions under Section 144 as decrees, even if they don't look anything like your standard trial conclusion. But on the flip side, the code explicitly excludes some things. Any adjudication you can appeal as an appeal from an order, or any dismissal for default, the law's clear. Those are definitively not decrees. Section 4. Types of decrees. A decree isn't always just a single dramatic drop of the gavel. It actually kind of matures in stages sometimes. First up, a court might issue a preliminary decree. This declares the rights of the parties, sure, but it also says, hey, we need further proceedings before we can totally wrap this suit up. It sets the baseline. Then, once all those remaining matters are finally hashed out, the court issues the final decree, which completely disposes of the suit based entirely on that preliminary foundation. And just to add a little nuance here, a single decree can actually be a hybrid, partly preliminary and partly final. Imagine a really complex case about a piece of property. The court might issue a final decree right now about who legally owns the land, but issue a preliminary decree regarding exactly how much rent the losing party owes. It basically leaves that super precise monetary calculation for later proceedings.
Section 5. Precedents and Case Laws. Let's move to and see how this builds in the real world, because it's absolutely crucial to ground all this dense legal theory in the reality of the courtroom. Take the case of State of Rajasthan v. Raj Singh. The Supreme Court observed and really reinforced that the CPC defines a decree incredibly strictly. That rigid structure of Section 2.2, it has to be respected. Courts just cannot play fast and loose when it comes to the formal expression of an adjudication.
Now, what's really interesting about this slide is the case of Adinargan versus Narasimha. It lays down a massive rule. Whether a judicial decision is a decree or an order is a matter of pure substance. It is not just about whatever label a judge decides to slap on it. If a decision is missing the fulfillment of any of those 5 essential ingredients we talked about, boom, it renders that decision an order. Partial fulfillment simply will not suffice.
So you might be wondering, why does all this hyper-meticulous analysis actually matter to us? Well, because the decree is the bridge between legal theory and your actual reality. It's the thing that translates a judge's intellectual reasoning into a rock-solid binding definition of your rights. Plus, whether a decision is classed as an order or a decree literally dictates the entire procedural path of any future appeals. It is, quite frankly, the ultimate difference between a temporary hurdle and a final enforceable victory. I want to leave you all with this final thought today. If a single missing element, literally just 1 out of 5, can instantly downgrade a highly powerful final decree into a mere order, how carefully must we be examining every single judicial decision? The law is entirely built on precision, and understanding that precision, that's where your true legal power lies. Thank you so much for joining me on this explainer. Keep learning, keep questioning, and I will catch you next time as we continue to demystify the fascinating legal world around us.